Do you hear me talking to you?
Narrated Buraidah, Allah's Messenger said, the judges have three types, two of whom will go to hell and one to paradise. The one who will go to the paradise is a man who knows what is right and gives judgment accordingly. However, a man who knows what is right but doesn't give judgment accordingly will be in hell. Likewise, a man that doesn't know what is right but judges people with ignorance will be in hell too. Reported by Al-Arba'ah and Al-Hakim, graded it Sahih. Whoever takes the position of judge or qadhi, it is just like he is subjecting himself to be destroyed. It is because he has to make a great effort in searching out the truth and do judgment correctly. Furthermore, he also will be subjected to his judgment in extremely accountability on the day of judgment. In case the judge turns out to be a bribe taker, so he will dwell in the hell. Narrated Ali, Allah's Messenger said, when two men bring case to you, do not decide in favor of the first till you hear what the other say. Then you will know how to judge. Reported by Ahmad, Abu Dawud and Al-Tirmizi. It states that passing a judgment by listening to the statement of the claimant is wrong, unless a defendant is given an opportunity to clarify his position also. In case a defendant observes silence, refuses to answer an interrogation, or doesn't care to attend the court on the specified date of hearing, then the judge has a right to announce the judgment. Narrated by Abu Hurairah, Allah's Messenger cursed the one who bribes and the one who takes bribes to influence the judgment. This reported by Ahmad and Al-Arba'ah.
Do you hear me talking to you?
Definition: come from word qarinah, literally connection, conjunction, relation, union, affiliation, association, linkage, or indication. Term of law: logical inference to be drawn from something done or from circumstance by virtue of which the matter become definite as sign which make the matter certain. Muslim jurists concur that circumstantial evidence is acceptable in crime of hudud and qisas. Circumstantial evidence is the evidence from which the judge may infer the existence of the fact on the issue but which does not prove the existence of the fact directly. Example: fingerprint, possession of stolen property, weapons used, opportunity, and motive. A presumption is a rule of law by virtue of which where a party prove one fact, primary fact, a second fact, the presumed fact, will also be taken to have proved, in the absence of evidence to the contrary. The Holy Prophet Muhammad PBUH has recognized circumstantial evidence as a source of proof in many cases. Example of the case: it has been related in the Battle of Badr, the two sons of Af'a claimed that they have killed Abu Jahl. The Holy Prophet said to them, "Have you cleaned your sword?" They said, "No." The Holy Prophet said, "Show your sword." When Holy Prophet saw the sword being blood-stained, he said, "You have killed him." The case of circumstantial evidence: murder and hurt, zina and zina bil al-jabr, rape, thief, drinking wine, presumption of legitimacy, presumption of marriage. Murder and hurt. Jurists concur that ta'zir punishment can be given in murder or hurt case on circumstantial evidence. The charge of offense of murder cannot be brought home in person unless his identity is fully and clearly established. Dying statement is a statement by victim in murder case before he disclosed the case and circumstance of his deeds. Motive. In determining the motive, the investigation officer should ascertain enmity between the deceased and his family or other that accompany him before the murder. Principles of circumstantial evidence in criminal cases are motive of accused, his threats, his opportunity, his preparation, his attempts, his false statement, his silence, etc. Zina and zina bil al-jabr, rape. Jurists differ whether or not pregnancy of an unmarried woman is sufficient proof of had of zina. Jurists concur that any other circumstantial evidence in zina, such as existence of semen on the body or clothes of an accused man or woman, and medical report shall be sufficient proof for ta'zir only. Rape. The mark of the violence of the genital and on the body of the victim or accused, presence of semen, blood stain, and medical report is sufficient for ta'zir. Fifth, jurists concur that ta'zir punishment can be given to the accused on any circumstantial evidence in this case. Drinking wine. Jurists concur that ta'zir punishment shall be given in this case or intoxicating material on circumstantial evidence or on the evidence less than the evidence required for the proof of had. Presumption of legitimacy. Child is born after 6 months of the valid marriage of the parents. The son is the legitimate child. Presumption of marriage. If man and woman state they are supposed and live like supposed, it shall be presumed that they have contracted marriage unless is given to the contrary. Documentary evidence. Evidence which is derived from a document produced for the inspection of the court in a matter under dispute. Document. Matter expressed to describe upon any substance which may use for purpose of recording of the matter. Majority of the jurists are on the opinion that a right or an offence liable to ta'zir may be proved by documentary evidence provided it is free from forgery.